Okay, so thank you, Simon, and thanks to BVI Finance for providing this space for specialists in our industry that can share a broader view on topics of interest. On that note, I'm pleased to introduce our panelists and key speaker. First up, Charlotte Bailey, Australian lawyer with extensive experience in corporate and fiduciary services in Australia, Jersey, the BVI, and the Cayman Islands. Currently appointed as Global Head of Conyers Client Services. During her time at the BVI, she led one of the top BVI corporate service providers, responsible for its operation and strategic business expansion. Also, she chaired the Association of Registered Agents and currently sits on the board of BVI Finance. Also joining us as panelists, Enrique Travieso, lawyer specialized in estate planning for high net worth families in Venezuela. Currently, Enrique is Managing Director of Corpac Services, New York and Florida, overseeing relationship managers, service office, and financial operation. Well in-depth, knowledgeable in corporate and fiduciary services, advising international clients with greater focus in Latin American markets. Last but not least, our speaker of the hour, Martin Litwack, Argentinian lawyer, admitted in England and Wales, and the BVI, CEO of Untitled, with vast experience on ultra-high net worth individuals structuring Latin American families, and well known for his insightful articles on wealth management and planning. Author of the 2018 publication, How Wealthiest People Protect Their Assets and Why We Should Do the Same. Welcome, everyone. Martin, the floor is yours.
Well, thank you very much for your kind introduction. I'll try to be brief so that we can then move to the panel discussion. I know let me try to share my screen and see if we can have the presentation here. Hold on a second. Okay, so here we go. Hopefully everybody will see my my screen now. We have to disconnect. Sorry for one reason, it's translating everything I'm saying. Okay, here we go. Sorry for that inconvenience. Beginning in 1998, with the first blacklist of offshore jurisdictions created by the OECD, and until present time, two macro trends have long influenced international wealth planning and international taxation. The first one was what can be called tax homogenization or tax cartelization, which implies a global race in taxes and the undoing of any traces of tax competition, and the invasion of individuals' privacy, which of course is necessary for the previous trend or objective. Both trends, as we will see, momentarily gain momentum after the 2001 World Trade Center attack, and continue to gain momentum, continue to grow until the changes introduced to the US tax system by the past administration. Unfortunately, this is sort of a summary of what we are going to see in the next 15 minutes. These trends are gaining momentum again, partially because of the change of government in the US, partially because of the pandemic we have all been suffering over the last year and a half. So that's kind of the summary of what we are going to see or to listen in my presentation. If we go 20 years ago, before these two macro trends started, we can see that a number of very common options or very common situations back then are really, or would be really extraordinary now in today's world. And this is important to understand that world is changing rapidly in terms of international taxation and wealth planning. And we need to be essentially paying attention to the trends when we are advising clients. And we will touch on certain changes that have been taking place lately. But just to review this, the information on this slide, only 20 years ago, in the 1990s, and some of us were already practicing law at that time, companies, and not only offshore companies, companies worldwide were able to issue bearer shares. Bank accounts could be opened in the names of a pseudonym or with a number only as the only identification. We have the strongest fiscal and bank secrecies. There were no exchange of information. There was respect for tax competition. This is mainly because most of the tax systems were territorially based. So you would pay taxes only on the income you generate in the place where you live, not overseas. That, of course, created very little cartelization. And it was also possible because of the lack of use of technology on those days. So there was no also risk of leaks that we see now every year, essentially. The situation in the high tax jurisdiction was starting to be complicated because of the, let's say, the retirement system, Social Security. Essentially, the population started to age in a different way, as you can see in this image, and the deficit of these governments were growing. At that time, they started to target financial centers, trying to avoid tax competition and trying to increase their own tax collection. And of course, they first were honest, and they were saying that there are countries that have a tax system that was harmful for them. The problem is that nobody really paid too much attention with that explanation. And after 9/11, there was a big change in the communication strategy. The high tax jurisdiction have understood that if they, instead of criticizing the tax system of the offshore centers or the international finance centers, they would use money laundering or terrorism as their, let's say, explanations for their attacks to the offshore centers, then their message will be more supported. And they were right. Only a couple of months after the 9/11 attack, the US, at the time Bush was president. So just to be clear, this is not a Republican versus Democrat speech. At the time, Bush, clearly a Republican president, passed the US Patriot Act, or promoted the approval of the US Patriot Act, which was the first time that the US really invaded privacy of taxpayers, resorting to terrorism or the risk of terrorism, things like that. After that, it was really a roller coaster for the offshore world. There were a lot of countries that started back in 2002 to accept the impositions of the OECD. And then there were, of course, we all learn about the fines to Swiss banks, FATCA, Falciani list, the common reporting standard, which is FATCA with asteroids, Panama Papers, of course, Paradise Papers. So the world changed a lot, and essentially all traces of tax competition were removed, and privacy apparently was no longer a human right or something that was that needed to be defended. With Trump, there were some changes in this. Both trends, both macro trends somehow stopped. And actually, the one that promoted tax cartelization actually started to move backward. I mean, the most recent tax reform in the US promoted tax competition worldwide. 2018, 2019, and even the beginning of 2020 have seen a lot of countries reducing taxes, including high tax regime like France, for example, Hungary, China, Germany, and others. So, and in terms of privacy, from the 113 agreements to regulate, FATCA, 112 were signed by either Obama or Biden. Only one was signed during Trump's administration, and was the one with Ukraine, which follows clearly a political path more than a wealth planning path. Unfortunately, pandemic hit us March last year, and we have seen with very few exceptions where some countries reduce a little bit of certain taxes. For example, Portugal or Germany reduce tax on tourism and VAT. But most of the countries have increased income tax, have created or increased wealth taxes, and have moved from territorial tax system to a global tax system. In the case of Latin America, for example, before the pandemic, only 3 countries had wealth taxes, Uruguay, Argentina, and Colombia. Now Argentina has approved a second wealth tax. On 18 December last year, Argentina became the first country in the world to have 2 taxes on wealth. And then Bolivia approved the wealth tax. Then Chile has a project in the parliament, same as Peru. There are rumors in Mexico, there are rumors even in the US. So the trend has changed back to tax homogenization. And for those who are thinking, well, this is the pandemic, the taxes will go away, this is a special situation, extraordinary situations require extraordinary decisions, let me remind you that there were a lot of situations where extraordinary situations created taxation or taxes, and now we have essentially those taxes for hundreds of years in some cases. So the important thing is to understand the situation, to accept it. Same thing we were saying when we explained, FATCA or CRS 5 years ago, and there were people saying, no, this is not going to happen. Switzerland will never give out information. Well, they were going to do that, and they did it. And here we are going to face further attacks on offshore centers. We're going to face very little competition. We're going to face higher taxes. We're going to see less privacy. So the sooner we understand this, the better we can advise our clients. The problem now, and why I'm positive about this, is that the problem 20 years ago was only the Social Security and essentially the retirement plans. Now we have seen a growth of social plans, universal basic income, increasing minimum wages, the growth of left-wing populism in the region. I just mentioned a few examples, that we have elections in Peru coming in 2 weeks. We have elections in Colombia, and both of them don't look nice. And we have, of course, all the stimulus programs that are a consequence of the pandemic. But even if we eliminate the stimulus programs, there are 4 new sources of deficit for countries which call for increase in taxation, reduce of competition, and reduce of privacy rights. If we go back to the latest demands before the pandemic hit us, there was a requirement from the OECD and the European Union of economic substance. Most of the countries have complied with that. BEPS, also most of the countries have complied with that. There was an intention, which actually was resulted on a blacklist of jurisdictions that promote immigration. There was the first one, I think, in 2 years ago by the Economic Union. And there are 2 more things that the OECD, the European Union, wants from International Finance Center. One is the public records of directors. The other is the public records of UBOs. You all know my position against that. But the point here is not my position or anybody's position, is what's going to happen. And probably at one point, this is going to be another green check in a future presentation. And that means that, again, clients need to structure their wealth now more than ever. Going back to politics a little bit, the Biden-Harris administration has been promoting the cartelization for the first time. The US is working hand in hand with the OECD in trying to put these items in the agenda. Corporate worldwide corporate tax and things like that. We'll see a quote from Yellen later when we finish the presentation, or before finishing. We're waiting for the increase in corporate earning tax to happen, to take place. We're also waiting for a reduction in the non-taxable portion of the estate. We are seeing the relaunch of FATCA. I mean, going back to the situation in Latin America, only 3 weeks ago, the US have signed FATCA, but IGA with Ecuador. There are rumors about tax on wealth, tax on financial transactions. As I said before, this was before Yellen office. she was saying that the US can increase taxes as long as that is coordinated with other countries. The good thing about this is that at least they are being honest about cartelization openly. Remember, in each of your countries, the owners of 20 supermarkets go and meet together and say, hey, we're going to sell the milk at this price. That's illegal, and people can go to jail. If countries do this with the taxes, then this homogenization is called. So we have to have our eyes open. There are examples. That's two things I'm going to say before finishing my presentation. This is not theory. Just after a month after Biden won the elections, the Corporate Transparency Act was approved, and this act allows for two lectures or two different readings. The first one is, of course, there's a new attack on privacy, but I'm going to elect to have a positive view on this. This is a proof that the BOSS system, the beneficial ownership search system in the BVI, is actually the right way to go in terms of UBOs. This is the US approving a legislation where the information on the UBO needs to be communicated to FinCEN, but doesn't need to be publicly available. And I think that's a good compromise between transparency and privacy. And we all should be fighting for this sort of compromise. We cannot have one of these value to overcome entirely the other one, because both of them, transparency and privacy, are very important values. And actually, privacy is a human right or individual right. Transparency is a need of the government. So, privacy should be more important, but at least it's good to reach a compromise and try to sort this out. The second one, as I said before, second example is FATCA. FATCA is going to go full speed now. There are probably another 8 countries to sign. In the case of Latin America, the ones that didn't sign were Argentina, Bolivia, and Uruguay. I would expect that this will be corrected during Biden's administration. Now, to finalize, 3 pieces of advice that we always use when it comes to estate planning. First one is a Chinese proverb: the best time to plant a tree was 20 years ago. The second best time is now. This applies entirely to estate planning. As we said before, and as we saw at the beginning of the presentation, a lot of things that 20 years ago were possible are not possible anymore. The same will happen if we compare this day with 20 years from now. So a lot of things that we will discuss in the next panel actually and can be done in the BVI in a very well manner probably won't be able to be done in 20 years. So it's not you have to hurry, but maybe a little bit. Second one, there are no diseases but sick people. And with this, I try to explain to clients that, and also to my lawyers, that there is no one solution fits all. I mean, you have to talk to the clients, see their needs, see their risk they face, and come up with a solution for them. So it's more important their special needs than where they live or what asset they have. And the last one, but not least, is the perfect is an enemy of good. And this means that maybe you see a client and you think, well, this is a client for a private fund structure with a trust on the top, and maybe they're not ready for that. And it's not good for them not to do anything. Maybe it's good to do a business company first, maybe do a will or have a joint tenancy, and then slowly try to educate that client for them to reach the ideal structure for them. And Michelle, I go back to you with this latest thinking.
Well, very insightful, definitely. Thank you, Martin. As usual, great acumen. The pressure is undeniable. We have learned in the past days that it seems quite decisive, the position adopted by G7 in order to reach a consensus in this global corporate taxation, which would be leading up to negotiations that would take place in OECD in Paris later this year. Actually, according to Bloomberg Tax, the Biden administration has begun to engage with other countries in the OECD with a proposal to simplify the OECD tax, or I should say global tax on multinational companies. It has extended to the UN with experts talking about the discussion and proposing the same global corporate minimum tax and discussing on options for taxing high wealth individuals. Jake Sullivan, US National Security Advisor, tweeted during the weekend that the world is closer than ever before to global minimum tax. All of this, of course, raises a lot of questions. First of all, is this just talk of this minimal global tax rate? Is this realistic or just a political posturing? In your view, Martin, can countries fully agree on something so fundamental?
The problem here is that actually there is no need for all the countries to agree. It's essentially the OECD and the US. And the US was always, very vocal about offshore centers, but they really didn't do too much. Obama was very aggressive on Cayman Islands in particular, but at the same time they have Delaware and they have a lot of structures that allow people to structure wealth in a very efficient way from a tax perspective. But now it does seem that there has been a change. I think that Biden's policies in terms of taxation are way more liberals than Obama's actually. And if the OECD and the US work together, again, they don't need that all the countries buy into that. I mean, remember that the US alone imposed FATCA over the world. So I'm really, for the first time in 20-something years, I'm been working offshore. I'm really pessimistic about this, unless we can come together and offer an alternative that could lead to a compromise.
Thanks. I don't know if any of the panelists want to add.
Enrique here. I would like to add something, to complement Martin with the nice presentation. I think, it's both a political and a realistic thing because, as Martin says, the US is talking together with the OECD, and for the first time compared to last year or the previous administration, you can see that this administration is fully open, to compromise on a corporate tax rate. However, you can see that they're talking of a 15%, globally. However, the current administration is looking to increase the corporate tax rate here in the US from 21 to 28%. So there you can see a bit of nonsense, if you put it in one way, but that will be my comment there.
Thank you. So also in that same, thread of lines is the US is known for their global taxation under its citizens. So how things are progressing, all the things that we're seeing that are cooking up, the potential consequences if other countries do follow the US and OECD in implementing this type of citizen global tax?
Well, I don't know. There are only two countries in the world that base their tax system on the idea of citizenship. The US and Eritrea. I don't think we'll see a change of countries shifting from residency to citizenship, but I do think, and I mentioned this before in my presentation, there are a lot of countries that traditionally have based their tax territorially. They are now thinking of changing to global income tax, or global tax system. Again, based in the concept of residency, and I think that that one of the things that this is one of the reasons why we have seen the EU blacklist of countries that immigration or second. I think that that's probably going to be the next battle, because when you if you don't allow people to structure their wealth staying where they are, you might start seeing people moving to other countries that are more efficient. That has happened, for example, in Argentina with the new tax on wealth. A lot of people moved to Uruguay, for example. So I would expect that at a certain point, if Colombia raises the taxes that much, they probably people will go to Panama, which is next door, and things like that. So people are starting to move, families are starting to move, or to allocate the assets to some of the individuals that live in different countries. So this may be the next big fight once the current fight is settled.
In addition to that, Martin, is like you were mentioning, for example, the country that is currently changing that, and they say they're going to change is Bolivia. There used to be for the entire, for many years territorial tax, and now they're going to change. And you can see the trends on Bolivian clients now structuring, and they're afraid, of what's going to happen next. Also with Argentinians, that they're moving, to Uruguay or to, and also you have Peruvians moving to Paraguay, for example, moving their full operations there, So I think, if in terms of political wise, it's going to be hard and people are going to be moving to different places. However, you can also see that a lot of people move to the US and they become, they enter into this global worldwide tax, So, it's a matter, like Martin said, to wait to see what's going to happen, in the next coming years.
Absolutely. Actually, the following question is in terms of the current socioeconomic distress that we're facing as a result of the post-pandemic and economy, that we're living in. So can any of the panelists suggest approaches to minimize the tax pressures caused by the government's plans?
I think that one of the important things here is that most people don't really know about taxation. They don't really know that maybe 100 years ago, well, not kind of maybe 100 years ago, only 5 countries have income tax regulation. So people have been very passive, and I think one of our roles, in addition to help our clients, is to try to train people and explain them what options there are out there and how they can propose changes to the governments. Not every country is the same. There are countries that have a lot of tax pressure, which means that even reducing taxes, they can actually collect more. So each country is different, but I think that a lot of times people just don't know about taxation. And again, I think that's our role should be also to try to teach them or train them, or at least make information available. I mean, for many years we were more passive, trying to defend what we've been doing, more than explaining how offshore centers actually have a different view. And I don't want to go again into politics, but until 1841, no country taxed income. Now we don't tax income in most of the offshore centers, and that's it is not us that changed our view on taxation. It is the high tax jurisdiction who did that. So we need to explain a little bit of the origins of all these taxes: tax on wealth, the tax on income, which are the consequences of this. I mean, a lot of time, tax on wealth, for example, and I always refer to tax on wealth as tax, more than tax on wealth, on tax on future poverty, because at the end of the day, the poor people depends much more on the success of the economy than the rich people. And if you tax wealth, you are essentially creating the wrong incentives to save, to invest, to create work, to create employment, to have good salaries. So at the end of the day, maybe in the short term, a wealth tax is paid by the rich, but in the long run, it's a really bad tax. Actually, when France eliminated it, I think it was 7 or 8 years ago, they said that they lost more money in income tax for businesses that they were not created than the money they collected through the wealth tax. So it's not just about increasing taxes and creating the most innovative tax. It's think about what will maximize the revenues of the governments, at the same time not interfering in the private activities of the private sector.
Exactly, Martin, you made the point of the right of privacy. With the trends towards extraterritorial law, as we have seen and experienced with global standards of exchange of information, such as FACTA, CRS, and beneficial ownership reporting, it seems that there are 2 fronts. There's tax on the wealthy, as you have clearly addressed, and financial transaction reporting for transparency purposes. In your opinion, what are the outcomes of these reporting exchange? What is the end game? And where are we heading with this? And more importantly, what should we be doing now to prepare for this?
Well, I think we need to plan wealth as if there were no privacy, because at one point there will be no privacy. And that's going to be really, really bad for the people. And I think a lot of people will realize this very, very far away. on time. I remember once I had a discussion with one of these so-called investigative journalists after Panama Papers, and he was of course attacking Panama and offshore, and I was of course defending. And at one point the last 5 minutes of the interview were about transparency and privacy, and I said to him, I said, listen, let's just shift the discussion. Let's not discuss tax. Let's go to another problem that we have in the world. Let's talk about domestic violence. And he said, okay, it's fine. Okay, so let me suggest something to terminate with domestic violence. Let's build all the houses in the whole world with transparent glasses, crystal. That will end up, I mean, nobody will hit the wife or the husband in front of everybody else, right? And he said, yeah. And I asked him, and what is the cost of that? And he said, well, that's huge cost. And that's the problem. We are not seeing the huge cost associated with the loss of privacy. And once again, I mentioned this before, when you have two rights that collapse, you have to see which right is the most important one. When you have a right of the people and mere interest of the government, there should not be a discussion. We should all have privacy. The only thing government needs to worry about is to have a way to find out the information if there is a crime or there is some illegal activity. So I don't mind sharing all my information and put all my information in a place that if I do something wrong, the government can easily access. What I don't think is right is to put out all the information for anybody to see if I behave correctly.
Understood. Yeah, it makes perfect sense. Hopefully the authorities have the same view on this. So we have another question here. What recommendations would you suggest, and this is open to the panelists, to the demographic that is being affected by this tax increases? What should we do? What should we be doing now, again, to mitigate this impact? Because it's clear that that is imminent and that we should be thinking about how to prepare. So I would like to hear from the panelists, your thoughts and suggestions.
I'll take that one, Michelle. Thanks so much. It's been interesting to listen to everyone's opinions on this so far, and I think I just thought about this from a very practical level, because I think obviously there's two different things here: the sort of the global tax and taxing the wealthy, but the global tax side of it and what the OECD are preparing, part of tier 2 is to be taxing the multinational companies. So that's their main focus. So, and that for the BVI is, a company that would be earning more than $750 million in profits, which would be reported, through the CRS, country by country reporting regime. So I guess in terms of who it's going to be affecting in the immediate future, it's those multinational companies, and many of those headquartered in our jurisdictions that are no tax or low tax. Probably not. But I suppose so. The issue in terms of the BVI and how it's going to affect the BVI and preparing for that, I think, is really about communication. And I think we saw there can be a lot of propaganda around the way that and who the changes in any type of regime affect. Economic substance was a perfect one. Lots of different messages went around the world in terms of how it was going to affect people and companies generally in the BVI and other jurisdictions. And I think it's just a matter of making sure that from a jurisdictional and a registered agent point of view, that we're communicating with our clients on it. We've collected a lot of information on our clients over the years, as Martin pointed out, from UBOs to Register of Directors and now Economic Substance. And even through Economic Substance, I think we would be able to see from the information we collected, which of these entities were, all going to be affected by this global tax regime by the OECD. So I think there's a lot to do around communication, preparing our clients for that. And from a registered agent's point of view, having a look at our book of work and seeing, how we can help and assist. But the difference is that if, from again a very practical point of view, if you are headquartered in, say, somewhere like the BVI and there's zero tax, and you're going to have to pay tax of the global tax rate, what's the difference of that compared to moving completely to another jurisdiction? So having a look at the actual financial impact of that global tax, should you have to be inevitably caught by it. But how is that different from moving completely to another higher tax jurisdiction? So I think, what we saw with economic substance, people trying to, shop around from a jurisdictional point of view, etc. But maybe in this case, it's just a matter of, taking a step back and seeing what the outcome is in terms of a financial, benefit or loss based on the introduction of these new taxes. From obviously a registered agent's point of view, making sure the communication is great with their clients, but also from a client perspective, I think Martin's already mentioned this many times, but make sure your house is in order. A lot of times, people haven't thought about this type of situation, making sure that they've got all the structuring and advice in place that they need, making sure they're taking the appropriate tax advice in the jurisdictions of which they're claiming their tax residency. And again, a lot of the time, it's actually not the offshore locations where they are claiming their tax residency. So it's a lot of thinking, I think, for people to do, but I think there's probably time for people to prepare. And I love Martin's first comment there, the best time to plant a tree was 20 years ago, and I'll remember that from my own life. But that's a really important thing. So it's don't sit there with your head buried in the sand, which I think a lot of people did with economic substance. This is coming, it's inevitable. And let's be proactive about it and, help and work with our clients where we can to make this as easy as possible for them. Cooperation is the key, working together, within our jurisdictions and within our client bases to make sure that, we can do what we can to make this as easy as possible for people.
Absolutely. I couldn't agree more with your comments. So we have a couple of minutes. I don't know if we want to do a round of final reflections. Who wants to start? Martin, perhaps?
Yeah, I think, we're a small player worldwide, but we are a big player in the offshore industry. I think we need to, as a jurisdiction, pick up what fights to fight. There are things, as Charlotte said, that are inevitable. And actually don't hurt that much. For example, economic substance, I remember when I was presenting on that legislation, I said, listen, this is going to affect 5% of our companies. And I think it was even less. So I think now the global tax is one thing we need to think about. There are other reasons why people in LATAM choose offshore and the BVI in particular to structure their wealth. There are a lot of things that are more related to political instability, to lack of rule of law, to safety, more than taxes, and of course state planning and things like that. So I'm not that much concerned about the global taxation, which again, it's not that I could do anything to avoid that, but I'm not that much concerned about that, to be honest. I think that the public register of beneficial owners, on the other hand, that's the fight to fight. At least for Latin American clients. If we understand what they look for, creating a register where criminals, journalists can access to all of your information is really, really very dangerous. I'm not promoting opacity or secrecy. I'm just promoting privacy in a region where you have, 46 of the 50 more unsecured cities. You have 3 of the 5 countries with more kidnapping. And this is not going to be better as a consequence of the pandemic, and the populism is probably going to be worse. So offshore jurisdictions in general have played a very important role worldwide. If you look at the history to provide protection to people who are unprotected. And that's one of the, let's say, our missions, and we need to stick to it. So I don't think that the fight should focus only on taxation or mainly on taxation. I think privacy is even more important than taxation at this point in time.
Yeah, and I would agree with Martin on that. I think the economic substance was a prime example of that, wasn't it? We all panicked at the beginning as to how much it was going to affect our clients, but then I think the global tax is another, maybe an example of that. I'm not predicting the future, but that's how the feeling I have at the moment. But those other issues, exactly what Martin's saying, are more concerning. The right to privacy and the sharing of personal information, etc., are ones where I can't justify in my own mind in terms of what that would achieve in terms of, you know, anything for the benefit of the global world. But I guess we'll see how that pans out.
Yeah, and from my side, in addition, I think, you know, like Martin says, and Charlotte, privacy, because what worries most our clients is the situations in their countries. You know, one day you have like a right side president, and then you have this, you know, like presidents like happening in Argentina. Like it changes so much the politics in Latam that some clients are afraid that their information is there. They don't wanna. They're not hiding anything, but they're afraid that something can be used against them. So I think we have to follow. Sorry?
No, I wanted to add something because as we were talking, I got a message on my WhatsApp with a publication of today in Argentina where a journalist has just published a list of all the people affected by the wealth tax who elected to fight that tax legally in the judicial system. So people trying to defend their right to fight a law that they understand is against the Constitution are exposed publicly. And this is the kind of lack of privacy that people are fighting when they come offshore. Sorry to interrupt, I just got the message and I thought it was a good example to share with everybody.
I think it's, yeah, that's the main thing, you know, and you see, you know, one day something happens, and I think in Latam it's like that all the time, you know. So I think focusing on you know, and helping our clients understand that it's a matter of privacy, you know, what they're looking for. So basically that's my side.
Well, thank you for all your comments. Thank you to the panelists and key speakers. Sadly, our time is up. So this is a topic most definitely that we need to look up for. So of course, in the following months, a lot of news in terms of the global corporate tax and more tax reform in our countries. Well, on behalf of BVI Finance, I thank again the panelists and viewers for joining this discussion. I now pass it on to Cristiani Matos for a second half topic in BVI We Trust. Thank you again and have a great day.
Thank you so much, Michelle. Welcome everyone to the panel BVI We Trust. BVI is one of the top jurisdictions about trust, and today we talk about some of the main features about the BVI trusts and why BVI remains as a hive of innovation, and also about some of the changes to the trust legislation that are currently in progress. Our panelists today are Claudia Weisbich. She is business developer and marketing at Trident Trust BVI. She has 20 years of experience in marketing and 3 years in the BVI industry. Our second panelist is David Peaches. He is a partner of the law firm Walker's Global Private Capital and Trusts Group. He has over 20 years of experience in wealth and succession planning and provides legal advice on aspects of BVI trusts and succession laws. Our third panelist and speaker is Chris Mackenzie. Chris is partner in the London office of the BVI firm O'Neill Webster. He heads the firm's BVI Trust Private Client Department, and he was the founding chair of the STEP in the BVI. He is actively involved in the BVI most significant trust and estates reforms, including both the BVI trust legislation and the PTC regulations. He is also author of most of the BVI's leading texts on trusts and estates. So welcome everyone, and Chris, the stage is yours.
Thank you very much, Cristiane. Can you hear me all right?
My pleasure, yes, perfectly.
Great.
Thank you.
Okay. Here we go. Sorry for that technical hitch. I'm not going to talk to you about politics or the OECD or politicians or taxes. I'm going to talk to you about BVI trusts. So here we go. So the BVI is, as you all know, the world's leading jurisdiction for company and corporations, according to an IMF report of a few years back. We have 45% of the global market share. We've also recently become the leading jurisdiction for private trust companies, and we'll be touching on private trust companies later. There are over 1,000 BVI private trust companies in existence. And as a result of reforms which started in 1993, and in particular our VISTA trust legislation, which we'll be touching on also, we are now one of the world's leading international trust jurisdictions. So trusts are used, first of all, for probate avoidance and estate planning. You won't need a grant of probate if you've set up a proper BVI trust with proper assistance. They're established to avoid disruption on death, since the assets have been transferred to a person's trust during their lifetime, and therefore death will be set up to run businesses and to own shares in companies. VISTA trusts in particular are used for that. They're set up to protect vulnerable relatives, such as young children, second families, that sort of thing. And they're used to preserve family wealth. They're used for asset protection. They're used to stop forced heirship provisions in a settlor's home jurisdiction from biting, and they're used to protect assets against matrimonial claims on divorce. They're also used for confidentiality reasons. Martin and Charlotte and the panel touched on the use of BVI vehicles for confidentiality, and they're used to further charitable or non-charitable purposes. Often non-charitable purpose trusts are set up to own shares in a BVI private trust company. They're a flexible way to hold assets. Most BVI trusts are discretionary trusts, which provide for a lot of leeway in terms of what will happen, and they're used for tax mitigation. I wouldn't say that they're used to evade tax, because nowadays in the BVI, as Martin and the others said, we all need to be tax compliant. So we can't use BVI trusts to evade tax, but sometimes the fact that the trust is set up in the BVI can mean that lower tax is payable or no tax is payable, depending on the advice from the home jurisdiction. So we have this special trust regime in existence in the BVI called the VISTA trust regime. Sorry, I muted myself by mistake. VISTA trusts are set up to own shares in BVI companies, and they remove all the problems of English trust law that arise from putting shares in a company in trust. If you don't have a VISTA trust, then the trustee has a duty to monitor the affairs of the underlying company to ensure that nothing untoward has happened, and that involves additional expenses, and it could mean that the intentions of the settlor of the trust are thwarted. You will need a BVI company immediately below the trustee in the structure, but below the BVI company, you can have foreign companies and any sorts of assets. The settlor to be the sole director of the underlying company and make investment decisions, or it doesn't have to be the settlor, it can be anyone selected by the settlor. And from the trustee's perspective, it absolves the trustees from all the concerns about liability, because it doesn't have to, and in fact it can't, intervene in the affairs of an underlying company except in certain prescribed circumstances. And a VISTA trust will also enable a succession mechanism for directorships to be implemented, directorships of the underlying company. And that's, I believe, unique to the BVI. VISTA trusts are very popular amongst settlors who want to stay in the driving seats, and a leading English QC a few years ago called VISTA Trust the mother of all settlor-controlled trusts. We also have legislation about protectors. What a protector is, as probably most of you know, is someone who has a role under the trust, but who isn't the trustee, and there's no reason why a settlor, the creator of the trust, cannot be the protector, or at least select who the protector is. Typically, the protector would have the power to change the trustees and maybe veto powers on distributions, but what powers they have is really a matter for discussion when the trust is set up. And this ability to have protectors is something that provides settlors with a lot of comfort when determining whether or not to pass over control of their assets to a trustee. And in fact, the BVI was the very first jurisdiction to have any legislation on protectors. Back in 1993, we implemented our first piece of legislation on protectors and enabling settlors to have control over trusts. But we'll be coming on to this in a moment. The legislation has been revamped very recently. We also have all the bells and whistles which you would expect to see in offshore trust law. We have legislation enabling non-charitable purpose trusts to be established. As I say, they're often set up to hold shares in private trust companies. We have an extended perpetuity period. Perpetuity period is effectively prescribes how long a trust can last. And we have a period of up to 360 years. We also have state-of-the-art provisions which enable trustees to deal with banks and other third parties in commercial transactions. That's much more difficult where the trust is a non-BVI trust. And we also have the most sophisticated conflicts of laws provisions in the world, or at least we will when the new statutes come into effect. Now, our laws on trusts and estates are kept under constant review. I initially, and now currently again, chair the committee which keep our laws under review. It's a committee of the BVI branch of STEP, and it's called the Trust and Succession Law Review Committee. It's been going since we founded the branch in 1997, and I initially chaired it, and as I say, I chair it again now. And our remit is to basically keep the law under review and to propose and suggest to the government law reform where we see this is warranted. And it was this committee which actually proposed the VISTA Trust legislation and all the amendments to the Trustee Act, which have taken place since 1993, including the recent reforms, which I'm going to talk to you about now. So I suppose the flagship reform amongst our recent reforms, these are set out in statutes which are on the statute books. They should come into effect very shortly. The first reform is one which relates to the variation of trusts. It's modelled on, our thinking was modelled on Section 47 of Bermuda's Trustee Act, which enables the dispositive provisions of a trust to be varied without the consent of beneficiaries who cannot, for tax reasons, give their consent. Now, I've dealt with a number of trusts in the past which have been set up against a backdrop of US taxation, where if the beneficiary consents to the variation, that will have negative tax consequences. This enables the court to basically stand in the beneficiary's shoes and provide consent on behalf of the beneficiary. However, this will not apply to all BVI trusts. It will only apply if there's a provision in the trust deed specifying that the section applies. Want this provision in or not. And it will also only apply to foreign trusts, and they can be existing trusts which were set up before the reforms come into effect, if when changing the governing law of the trust to the BVI, an election is made. So if you've got a foreign trust where there's a problem over varying the trust and needing the consent of a beneficiary, in that context, you have an option of changing the governing law to BVI law and making the election and then going to court to get the variation. So these provisions are also useful where there's a beneficiary with a remote future interest, which might block a variation, but there are all the appropriate safeguards in the legislation. And I should have mentioned that you will find very detailed summaries of the legislative provisions in my firm's website. You go into perspectives, and then you go to articles, and then you scroll down, and there's a summary of each of these sets of reforms, which is fairly detailed on the website. In due course, of course, there'll be lots of articles and so on published, but this is very early days yet. The legislation only came into effect earlier this month. So the next thing that we covered in the reforms was reserved powers. I spoke to you a little bit about this earlier. The legislation which we had enabling the settlor or protectors to have powers under the trust, was a little bit out of date because it was enacted in 1993, and so we needed to take stock and picked all the best features of our competitors' legislation and turned it into our own legislative offering. Now, lots of settlors won't give up ownership of trust assets. In other words, they won't set up a trust unless they have certain powers under the trust, or at least a protector has those powers. So we foresee as this development as providing a lot more comfort to those who want to settle BVI trust and have various powers. Now the next thing that we've covered in the Trustee Amendment Act of 2021 is the BVI's firewall offering. What the firewall offering is all about is insulating BVI trusts with BVI trustees against claims based on foreign law, like foreign succession rights after the settlor has passed away, or foreign matrimonial claims. And so there's a lot of technical legislative provisions in Section 83A of our Trustee Act, and we've basically strengthened that offering in some respects which are a little bit too technical to go into in a brief presentation like this. Next, we've got a new Probate Resealing Act, and what this basically does is implement a simplified procedure for obtaining a grant of probate where a grant has already been obtained in another jurisdiction. Before the Act comes into effect, it's only essentially UK and Crown dependency and UK overseas territories grants that can be resealed in the BVI. Now we've extended that ability to a long list of other jurisdictions, including jurisdictions like Hong Kong and all the states of the United States of America, Singapore, India, and a load of Commonwealth countries. So that makes getting a BVI grant of probate a lot simpler where you've got a grant of probate in another jurisdiction. Next, I want to turn briefly to trusteeship. There are over 150 licensed trustees in the BVI, which are fully regulated by the Financial Services Commission. So they have to conform to lots and lots of international standards and have capitalization and qualified directors and insurance and so on and so forth. So, and 90 of those hold unrestricted trust licenses, so they can take on any forms of new trusts that they like. On the other hand, if the settlor or the creator of a trust doesn't want to use a regulated trustee, what they can do now is set up a private trust company, basically their own trust company, to be the trustee of their trust without a license. Now, these are permitted in the BVI. As I said earlier, we have over 1,000 of them, but they do have to fulfill certain conditions. Of course, the corporate entity, a PTC is a corporate entity, and it has all the advantages of a corporate entity: perpetual existence, limited liability, and so on and so forth. And the directors can be the settlors or those selected by them. But if you want to set up a PTC, as opposed to using a licensed trustee, you have to fulfill various conditions. The principal ones are that you do not offer your services to the general public, and you satisfy one of two alternatives. You don't have to satisfy both of them. The first alternative is that you're not charging remuneration for the provision of trustee services. The second one is, and it's an alternative, is that you only act as trustee of various family trusts within the meaning of the legislation. So they're the basic criteria. There are a few other T's to be crossed and I's to be dotted, but they're the basic ones. BVI PTCs tend to be very popular when clients and their advisors look at what jurisdiction to use. They look at a number of critical factors: whether a license is needed, whether a local director is needed, whether there are any capitalization requirements, physical presence requirements, and so on. Well, we don't have any of those requirements. The fees are low, and the process is as confidential as setting up most BVI companies. And so all the boxes tend to be ticked. I just want to briefly touch on a couple of other probate avoidance vehicles for those who don't want to set up trusts. I understand in some jurisdictions there can be tax downsides potentially to setting up trusts. So if you have a client who's got a BVI company, one of your options is joint tenancies. Another option is having different classes of shares. And we also have different classes of shares in the memorandum and articles, and maybe we will touch on these issues in the panel session. We also have special reserve director provisions in the BVI Business Companies Act, which again, maybe we'll touch on in the panel session. But that's all I have to say for now, and I'll pass you back to Christiane, if I may.
Thank you so much, Chris, for a very enlightening presentation as usual. We have several questions. If we don't have time to go through all of them, please apologize, but feel free to contact us after the webinar, and we'll be happy to respond them. And Chris, the first question is for you. I think you went through that during your presentation, but maybe people would like more clarification on that. Why would one use the BVI as opposed to elsewhere to set up a trust?
Okay, thank you, Chris. Well, to start with, the BVI is a UK overseas territory, and so it's in the same position as the Falkland Islands. And so the British government is responsible for foreign affairs, and the governor is appointed by the Queen of England. We have a democratic and stable government. We have a world-class trust industry with some very good law firms and trust companies in it. We have tax neutrality. The there won't, if there is no BVI land involved and the beneficiary is not resident in the BVI, you don't tend to have any BVI taxes payable. Our court system is excellent. We're part of the Eastern Caribbean court system, which has been around for 50 years, so it's no new thing. And we have all the state-of-the-art legislation that I've just mentioned.
Thank you so much, Chris. Our second question is to Claudia. And Claudia, I cannot hear you. Are you there?
Can you hear me? Yeah.
Yes, thank you. Okay. The second question is for you. Thank you so much for being part of the panel as well.
Thank you.
So the question is, what happens if shares remain in a shareholder's name when he passes away and he's both the sole shareholder and the sole director of the company?
Well, if the person is the sole director and sole shareholder, if no succession planning steps are taken, an application for a BVI grant on representation will need to be made following the shareholder's death. So a future court application involving short a hearing before a judge is also needed after the grant of representation has been obtained. Another thing that Chris mentioned before is to appoint a reserve director. So this person will manage the company affairs when the sole shareholder passed away until the successions of the shares take place. Until the new shareholders will appoint a new director that can be the same person as the reserve director.
All right, thank you so much, Claudia. Chris, we have another one for you. Yeah, is there a specific reason why a trust cannot be set up? What other succession planning options are available?
Okay, yeah, thanks, Chris. Well, the first one, I touched on this so briefly a few moments ago, but let me go into more detail about the two options. There are a number of options which don't work. So don't put shares in a nominee name, things like, or use provisions in memorandum and articles saying no grant is needed, or do anything like that. The only three options really involving BVI structures at least would be the trust, which we've covered. And then the second option is a joint tenancy. Now, what happens with a joint tenancy is, for technical reasons, which I won't go into, the two people own the property as beneficial joint tenants. That's the legal expression. And what happens when one passes away is that the assets vest automatically in the other beneficial joint tenant. And so you don't need a grant of probate because it doesn't fall into the estate. But there are some downsides to this. One is that it just kicks the problem down the road. The second joint tenant is going to have a limited lifespan, as we all do, unfortunately. Another problem is that there can be a presumption of there not being a joint tenancy. I won't go into the technicalities, but if one of the two parties has provided the purchase price, you have a presumption of a tenancy in common, which means that the deceased owner's share goes into his or her estate. And at any time, one of the partners can convert the joint tenancy into a tenancy in common. So it's not entirely watertight and safe. So those are the principal problems. There are ways to deal with them, but ultimately a joint tenancy is nowhere near as flexible as a trust. It is essentially only a sticking plaster to deal with the short term, and I would really only recommend it between husbands and wives, if at all. Now, a more sophisticated option would be to to amend and restate the company's memorandum and articles, if we're dealing with shares in a BVI company, and I'm assuming we are, rather than real property, because it doesn't really work for real property. But if we're dealing with shares in a BVI company, you can amend and restate the memonarts to say that there are two classes of shares. The A shares would be held by the patriarch or the matriarch, or whoever it is, during their lifetime. And they would hold all the economic rights and all the rights to dividends and the voting rights as well. They would hold all of those whilst the person is alive. But the problem, and then there would be B shares issued to those whom the patriarch or matriarch wants to inherit the shares. They would be issued now, and therefore, and then when they pass away, when the A shareholder passes away, not only do the A shares lose all their economic and voting rights, all those rights pass to the B shareholders. So it's in a sense an automatic succession mechanism written into the memorandum and articles. Now these have taken off recently, particularly in Brazil, with Brazilian clients. But the problems, they're not insurmountable, but there are problems with these structures. And one is that if the intended B class shareholders are minors, those under 18, or incapable, then we've got a problem with those rights being vested in such persons. And I also always advise when I'm preparing wills, because I prepare a lot of wills for clients, that you need to be careful about transferring valuable assets to people when they attain majority, because it can mean that they forego education opportunities, they could become wayward, and they could become susceptible to the influences of boyfriend and girlfriend gold diggers. So that's the problem. Also, it's a problem where there are creditors' claims against the B shareholders, because the rights, even though they're future rights, have already accrued. So it is not anywhere near as flexible or as good as a trust to my mind. But if you need to do something, that will be the thing to do.
Yeah, thank you so much, Chris. So do you think we could say that there is a best succession planning vehicle? And if yes, if there is one, why? This was addressed to all the panelists, but Claudia, if you want to start with, and then if the others, they'd like to add something.
Well, I think Chris already explained, but the best one, it depends on your family profile. It depends on your assets. For example, if you are okay with your family, your relative, like your partner, I mean, like your husband or your wife, with your children, you can have a co-owner too, like joint tenants. It's okay. But if you have someone with disability or some special needs for a future generation, and you want to protect up to 3 generations, so you should go with trusts. It depends on the family profile.
Yeah, thank you so much. I don't know if anyone would like to add something?
Yeah, I would like to add in to that. My advice is always to don't make it too complicated. And as a trust lawyer, it sometimes sounds a bit counterintuitive, but the advice actually is: do you need a trust? Is a trust the best thing for your family? It's going to involve you having to interact with probably a third-party service provider, unless you've got a private trust company. And perhaps I'll come on to talk about private trust companies in a minute. But you may want all the advantages that a trust has, but are you prepared to put up with the potential downsides and the sort of intrusion that it leads to? I'd like to talk about private trust companies as well, because Chris gave a very good explanation as to what they are, and indeed Certainly, we are finding that we're setting up more private trust companies in BVI than probably any other jurisdiction, and I think there are a number of reasons for that. Structured and administered properly, a PTC can be a very effective tool for some families. It might be seen as the sort of ultimate in reserved powers vehicles. It allows the family to incorporate their own trust company to act as the trustee of the family trusts. They can sit on the board, or they can be represented on the board and effectively drive their own trusts, as it were. It's flexible. It has nimbleness, if that's a word. I don't think it is, but effectively, it can act. It can act quickly. It can react to opportunities when they arise, perhaps in a way that a professional trust company might not be able to, and it may have an ability to hold assets that might be beyond the risk appetite of a professional trustee. Is it always the best solution? No, in my experience. To succeed, it's very important that the family directors know what they're doing. They have to understand the role of a trustee. They have to understand the fiduciary nature of the role that they're taking on, that the considerations that they're going to need to take into account when they're making decisions, and the need for proper deliberation. They're going to need to appreciate the importance of adopting good governance practices. So, proper meetings, proper minutes, they need to respect the structure. And what I mean by that is, you want a distribution made, that's got to be done properly with due deliberation, and the funds have got to flow through the structure properly and not just be siphoned off the bottom like they always used to before they'd set the structure up. And in my experience, these are not uncommon problems. Thirdly, I would add to that the need for proper succession planning within the structure, not just the patriarch as the sole shareholder, sole director of the PTC. You need to build into it a proper, clear path for how the next generation is going to come on board. There can be several, different ways of doing it, but it is a multi-generational tool. You set them up because they have the facility to be multi-generational tools, and you need to build that into it. So I think the flip side, if the directors don't have that adequate understanding, they don't have good governance practices, there is no succession planning, not that uncommon, then you have mismanagement, you have family disputes, and ultimately you have a potentially quite a weak structure that's really not likely to stand up to attack from either inside or outside. And I think in those circumstances, a family might very well be better off with a properly structured and administered reserve powers trust with a professional trustee that's got both the sort of time, inclination, and specialist expertise to administer it. Sorry, I think I've gone on too long.
No, it's all right. Thank you so much, David. It's well put. It's very important to put the right structure in place, but also observe all the governance of the process as well, of the structures, to make sure that everything is taken care of and all the proper documents are prepared and you are not in breach of anything. So it's really important to keep that in mind when you decide which type of structure we're going to set up for your family. And since you were talking about PTCs, there are two other quick questions here. The first one, and maybe David would like to go ahead on that. Can a PTC be the trustee for either BVI and non-BVI trusts at the same time?
Yes, I think the answer to that is yes. I mean, provided that we are. I mean, as Chris has already said, that the one of the criteria for qualifying for the PTC exemption, so not being subject to the usual trust licensing requirements under the Banks and Trust Companies Act, is that well, either the trust company is not being remunerated for services, or it's that all the trusts are effectively related, and that's to work out whether they're related. You look at the sort of beneficiaries of the trust, but I mean, provided that is satisfied, and you know, if you're relying on the related trust business for your exemption, then I think you could, yes, there's no restriction on where the governing law of the trust is. I mean, I think it would typically be BVI, but there's no reason, you know, if they wanted to diversify, or if there was a particular reason they wanted a trust in another jurisdiction.
All right, thank you so much. And the other one is, can a family member be a co-trustee together with a BVI professional trustee or a PTC?
Well, should I take this? I mean, in theory, I suppose yes. I'm not entirely sure why they would be, or why they necessarily would want to be. I mean, I think from a practical perspective, a professional trustee, certainly in my experience, they tend not to want to have a sort of lay individual being a co-trustee with them. I suppose they might agree to it, but I think that's unusual. In terms of a PTC, again, I'm not quite sure why they would, because you know, the whole point of a PTC would be that individual could probably sit on the board of the PTC and influence trustee decisions in that way. As I say, yes. I mean, I don't know if any other panelists have got any thoughts on this, but I'm not entirely sure why that individual would want to do it. I mean, you'd be undertaking, or you know.
I think the answer would be, yeah, there's nothing in the legislation preventing, but there is no point, because the family probably will sit down.
Think carefully before you take on an individual trusteeship, I think would be my advice.
Yeah, and some trustees won't take on co-trusteeship as well.
Yeah.
So.
Yeah. Thank you so much. And Chris, the next one is for you. What are VISTA trusts and why they are so popular?
Oh, I think I covered that earlier. Basically, VISTA trusts, the VISTA trust regime is a special trust regime set up where the asset, the trust asset is shares in a BVI company, and it gets around two problems of English trust law, which apply in all English law-based jurisdictions, except where they've modified their law. And the first problem is that the trustee might have to sell the shares if a good offer comes along. But the principal problem of English trust law is that as a result of an English Court of Appeal decision in a case called Bartlett and Barclays Bank, trustees have a duty to monitor what's good. Trustee shareholders, because trustees own the shares, simply in their capacity as shareholders, they have a duty to monitor what's going on at the company level, at the director level, to ensure that the value of the trust assets is preserved. And if the directors start taking commercial risks, that's not really permitted from a trustee perspective, and therefore they might have a duty to change the directors. If a settlor has set up a trust where the asset is shares in his or her company, that might thwart the settlor's intentions if they're the sole director, say, and want to continue with this commercial risk taking, because it's the commercial risk that has probably made the company profitable, whereas the trustee has to sort of put a lid on that and make it all conservative. And it's a recipe for a fallout with the settlor, because the trustee is concerned about its exposure to liability if the risk-taking proves the wrong decision in retrospect was made, or they might feel compelled by settlor pressure to carry on doing things as a settlor wanted, and then expose themselves to liability. So VISTA gets around this conundrum by saying that if you opt into this trust regime in your trust deed, the VISTA rules will apply. So the trustee cannot intervene except in circumstances set out in the trust deed, and we normally set out some limited circumstances like director fraud and that sort of thing, where the trustee wouldn't want to be at the top of the structure. And so everything can continue as the settlor intended, and everything can continue as it used to be done when everyone was exposed to liability. And it can be continued because the VISTA legislation says it can, if that makes sense.
Yes, thank you so much, Bruce. Thank you. And since we're talking about VISTA, one of the questions is, what if a settlor is not prepared to transfer the ownership of trust assets to a professional trustee? Does he have any other options in terms of trusteeship? I think you already addressed that in terms of the PTC, I guess.
Yeah.
And the next question is, can a VISTA trust hold assets other than shares in a BVI company?
Yes, it can, but those assets, if directly held by the trustee, rather than below the BVI company, they would be held on the same trusts, all the other provisions of the trust, other than those which are VISTA related. So the trustee would have its duties and so on if it's held directly, because VISTA can only apply to shares in BVI companies. I really need to do a structure diagram to explain this, but basically if you have the trustee at the top and you have the BVI, the shares in the BVI company immediately below, then VISTA applies to that. But if you have other assets held in the same trust, they're held in the same trust but not subject to VISTA. However, if those assets are held underneath the BVI company instead, through the structure to prevent the trustee having any concerns about those underlying assets.
Thank you so much. We have a very interesting question here, and I think maybe David, you might want to answer that one. As we have seen in the latest revisions of the trust legislation, BVI trust law is a state of the art within the industry. Are you seeing BVI trusts being used in innovative ways? What new opportunities are you seeing for trustees, and what are the issues that need to be managed?
Well, yes, we are, and I think perhaps we're seeing developments in two related areas. Firstly, we are starting to see trusts used as solutions for clients in applying blockchain technology, and in this context, we're talking about DAOs, which decentralized autonomous organizations. So networks, communities of stakeholders in cyberspace operating together, conducting business together in common, usually for profit. There is generally no central governance structure. The rules of the organization are set out in computer code and sort of run or function autonomously. They're usually incentivized by a system of tokens. The transactions of the organization are stored transparently on a blockchain. Decisions are taken pretty democratically by stakeholder vote. if a proposal is approved by a majority of stakeholders or in accordance with whatever the sort of consensus rules of the network are, then it's implemented. The issues arise, though, when these organisations need to or want to interact with the real world, and the question then becomes, well, there are typically, I suppose, three problems, all related to what is the legal status of these organisations. Two or more persons carrying on business together with a view to making a profit sounds a lot like a common law partnership. They probably don't want to be a common law partnership because partners have unlimited personal liability for partnership debts. And so, and if that analysis is correct, then stakeholders may find that they're answerable for all the sort of acts and omissions of all the other stakeholders. The second issue is, how does the organisation enter into contracts? If they want to employ someone, or they want to open a bank account, something like that. And thirdly, how do they hold property? There is a need for a real world entity, a legal person through which they can transact, that can provide them with limited liability, and which can hold property. And there are a variety of solutions to this, and I think it's fair to say that it's in its, well, not in its infancy, but the whole issue of decentralized control is still being thought out. But private trust companies and trusts are one of the methods that we are seeing used to try and give some to sort of give this real world connection. So the trustee provides the legal entity, it holds generally tokens or maybe other assets for the benefit to apply them for the benefit of the community. And that is one of the ways that this is being done. There are other ways, I hasten to add, and I'm not an expert on this area. I have to say, I know there's a new LLC product coming that's being developed in the BVI at the moment, that's specifically looking to solve this solution, to solve this for these organisations. And I believe that's coming out later this year. The second area that perhaps we're seeing is the holding of crypto assets as cryptocurrencies as an asset class, and trustees being asked to hold cryptocurrencies and having to work out one, how do we do it? And how do we do it in a manner which is secure? Given the sort of well, we've heard in the news about sort of lost wallet keys and these assets sort of being irretrievably lost. And the second issue is the broader question of, should they be doing it? How does holding cryptocurrencies tie in with the trustees' fiduciary duties? Is it a prudent investment? How can they protect themselves? Does the volatility that's inherent in these cryptocurrencies prevent a trustee from investing? I suppose the first question is, well, what are you actually being asked to invest in? Is it Ether or Bitcoin or one of the sort of more established, albeit pretty volatile, seems to me, cryptocurrencies, or is it one of the thousands of mad, bad, dangerous to know other cryptocurrencies that are out there and sort of operate pretty much like Ponzi schemes, as far as I can see? And also, are you, if you decide to do it, custodianship is key to this. Are you using an investment grade custodian? Those sorts of considerations. Are you adequately protected under trust deed? These are all things that the trustees are now looking at. I think I'm going to stop there. I have to, as may well have become apparent from this. I'm not a tech expert, but as trust lawyers, we are being asked these questions, and we are becoming involved in setting up these structures. And so, it's becoming important that we do talk to our tech colleagues and our regulatory colleagues and start to get to grips with these issues.
Yes, thank you so much, David. That was great. Thank you. We have another question for Chris about licenses. They are asking, do you know how the trust license are determined? And for example, can several licenses be issued to the same group company? Sorry, Chris, I think you're on mute.
Sorry,
Yes.
my connection's unstable. So I think I saw the question in the chat. I believe this is not my area of the law at all. I don't deal with trust license applications, but I understand that licenses can be issued to the same companies within a group, but that the Commission has changed the rules recently, and I don't know whether someone from a trust company might know more about the issue than I do, but essentially there is no legal impediment, as far as I know, to multiple trust licenses being issued to companies within the same group. The licensing process tends to be quite a detailed one. It's maybe like applying for nationality or something like that. It's not exactly a tick the box, fill in this form and send it off approach. You have to have capitalization, you have to have insurance, you have to file a heap of paperwork, and then the Commission meets frequently and discusses the application on its merits, but it needs to ensure that this is the sort of trustee we want in the BVI, a regulated entity, and that's why we have ATU and Trident and all those big household names. For a smaller organization, it might be a little bit more tricky to get a license if you don't have, say, at least 2 senior directors with solid and practical experience in trust legislation, trust administration, which is one of the key requirements. But that's all I can really say on this subject, because the last time I was involved in applying for a trust license was over 10 years ago.
Thank you so much, Chris. That's right. Like, we have different process for different types of license and different requirements as well. So we have to decide which one is the most appropriate, and then to see if the Commission is going to grant them or not. We are coming, we're short of time at this moment. We have 2 last questions, and then I will open the floor in case you have any additional comments. So the last 2 questions are about trusts as well. The first one is, can a VISTA trust be discretionary? And the second question is, can the trustee transfer assets out of a BVI trust? Would you like to take those ones? Can a VISTA trust be a discretionary trust?
Yeah. Well, yes, it can. I think perhaps the point to make about VISTA is it addresses the administrative functions of the of the trust rather than the dispositive functions. So the VISTA attaches to the shares of the BVI company, and as Chris has explained, disengages the trustee from that process. What it doesn't do is have any impact on what the dispositive provisions are in the trust. So you can have a perfectly, as with any other trust, you can have a discretionary trust with VISTA applying to the shares.
I would say 95% of BVI trusts are, 95% of VISTA trusts will be discretionary trusts. In Asia, they tend to make a distinction between a discretionary trust and a VISTA trust, but that kind of confuses the issue. There is not such a distinction.
Yeah, thank you so much. And And the second one would be, can the trustee transfer assets out of a BVI trust? Does the trustee require the settlor and or the beneficiary consent or seek guidance from the court prior to the distribution of those assets or transfer of those assets? I think would be more appropriate here.
Shall I do that one? Well, basically, I mean, VISTA doesn't prevent the trustee from doing anything in relation to the transfer of the assets. They can't sell shares in exercise of investment powers, but VISTA doesn't affect the dispositive provisions of the trust. So if the terms of the trust are such that the assets can be transferred, then they can be transferred by the trustee without any consents or court approval, unless in the very unlikely situation in which such terms are written into the trust. And I can't think of a trust where I've come across such a situation.
Thank you. I'd like to open the floor. I think we went through too many different features for the different types of trusts that you have in the BVI. It was a very enlightening presentation. But I don't know if you'd like to make any final comments before we close up.
Fine, thank you.
All right, if you don't have any final comments, I'd like to thank you all the panelists very much for your time and for very, very good answers. I'd like to thank BVI Finance as well for creating this opportunity for us to discuss more about the BVI trusts, the services that we provide here, and clarify many things that normally are queries that we receive quite often from clients. It's an opportunity as well for us to exchange experience, to educate everyone about the BVI services, and to try to improve the governance as well. So thank you very much, everyone. We hope you enjoyed this session and hope to see you in future webinar. Thank you.
May I take this opportunity to thank you, Christiane, and Michelle for your expert moderation of this very important set of panels, and of course extend our thanks to all of our panelists for your very valuable time and very useful contributions. Much appreciated. Just to advise anyone, we will be providing the recording and indeed the slides, and if that provokes further questions, then feel free to reach out to any of our panelists individually, or if you wish, through myself. But I just want to reiterate my thanks to the panelists, the moderators, and most importantly, our audience. This is the first of a series we're doing throughout the year in most of the continents, and we do hope you will join us for future sessions. But thank you all very, very much indeed.